welcome then to this last webinar or last lecture on the webinar for the course Introduction to Commercial Law 2017. We will have one more webinar, but that will be the summary, so this will be the last lecture. Before we go into today's subject, which is continuing the tax law subject, I'm going to talk a little bit about the assignment. So let me just switch over to another computer here. And you should have my home page now up there. We have the group assignment then. I got a few questions on the blog that I've been trying to answer. So first of all, to download your assignment. So we had a deadline at latest December 13 at 12 a.m. Okay, I must admit that I missed that. I thought it was December 14. So that means that I will fix that you can get hold of the papers that you're going to do the opposition on. I will open it up then directly after this webinar. That was my mistake, really. I was convinced that it was 14 here. Sorry about that. Anyway, I had someone who asked how to upload. Most of you probably have uploaded now then, but the way to do it, if I go to group 13 here, instead of putting it as an issue here, I mean, that of course you can do that, but that makes it more tricky for other people to find it then. So the instruction was to put it up here on Documents. So you click on Documents and then New Document, and you choose a file, and then you upload it that way. So that is how you should do it. I'm going to see how I can get out of this too. Okay, so that was just the uploading of the assignment. And you do the same thing then with the opposition that you're writing down. You upload that also. If we talk a little bit about the final, the seminar then. So let me go back here to the schedule, and we had, let's scroll down to the seminar assignment group schedule. So we have 2 days here, and when you look at on 18 then, at 8:15 to 12, we have those groups, and the thinking here is that you're going to stay on the webinar the full time from 8:15 to 12. So you will join and listen to the other people's presentation and the opposition, and hopefully we can also get a little bit engaged in a discussion if we understand the case, because it is a little bit like this. When you present the case in 5 minutes, all other group, besides from the opposition group, they haven't read your work. So the presentation should be so good so they can understand your work. And also be able to make a little bit of comments on your analysis. So you should focus on your presentation, the 5 minutes presentation, that it is so clear and so good So someone who hasn't read the case should be able to understand what you're talking about. Try to divide between all of you in the group the presentation. I know that it's very short period of time, and if you are five people, you have 1 minute each. That's going to be really tricky, of course. But then you can do, if you are 5 people, and then you can have maybe 2 or 3 that is doing the presentation, and then the other 2 or 3 are more active than in the discussion after the opposition group has made their presentation. The opposition group will have a little bit more time then, because they have 10 minutes. And also if you don't do the presentation orally, then you can of course be on your opposition. You can divide it so everybody has to speak a little bit, because I'm just going to have your names on a list, and then I make a mark who is talking, who hasn't performed anything else. And I of course want everyone in the group to perform something. I do understand that some people think it's very painful to stand in front of people or sit in front of people and talk, and also in English then, for you who don't have English as a native language. But it's a training. I mean, we shouldn't be too hard on us. I mean, we all make mistakes, and it's not that easy. So don't feel nervous about this. I mean, we all do the best we can. That's what counts, really, when it comes to the presentation, because you haven't got any training in how to do the presentation. So, and I'm aware of that, and I know that some people think it's very painful. But that's going to work. And then after the opposition, you focus on your oral opposition. You focus definitely on analysis, on that part. And try to ask questions if you didn't understand what the group meant in their analysis, and make comments if you feel that they have done something wrong in the analysis, that they haven't picked up the right things, that the conclusions are wrong, or but focus on that. But in the opposition, in the paper, of course, you should mention all different areas of the work regarding facts, issues, and judgment. Also, but in the oral opposition, try to focus on analysis. And then I will also open up a short period for if there are some general questions from other groups and that hasn't read the paper but just has been listening to the discussion. If they have anything else to add, we will open up for that too. And then a little bit depending on how much time we have. But as you can see, we have quite a lot of groups. So we need to keep a tight schedule for it to work. But that is a little bit my plan. Let me see now. Otherwise, on the home page, if we go down, I've uploaded. It was very late. I had some computer problems again. So the movies came out late from the last lecture, but they are out now, part 1 and part 2. And the slides for today's lecture is out. One more thing also very important. Don't forget to register for the exam. Because if you don't register within or before 10 days before the exam, you won't be able to write the exam. So I'm really pointing that out now. Don't forget to register for the exam, because there is no way I can get you in. If you forget to register, I can't help you. There is no way I can do that. I got a question here. Is it open? I don't know if it is open yet or if it opens up on 15th. tomorrow. Okay, someone answered here that yes, it is open. Okay. I'm gonna put it out on the homepage too, on top, that you must register for the exam. Very important, because every time, every class, every year, I have someone that writes to me and say, "Oh, I forgot to register. Please, can you help me?" And I'm sorry, I can't do it. There is nothing I can do. Okay, that was that. Let me go then to the blog and see. We had a few questions regarding the webinar or the seminar then, but I think I answered those. And I also made a written answer here. Yeah. Oh, okay, for Henrik here, it's good if you try to upload it, the work again in under documents, so you get it in there. Okay, perfect. Then we go over to today's Twitter question, and it came out a little bit late today. Well, I missed that yesterday to put it out in the schedule. So it came out a little bit late today. But it's there now. What does credit method mean in tax treaties? That we're going to answer today. What does credit method mean in tax treaties? Okay, and then we are ready to jump into today's subject then. So I'm going to switch over here to the PowerPoint slides. And we should have this on the screen then, international taxation then. And we're going to start the lecture by talking a little bit about different taxation methods in countries. We are talking now about how different countries are deciding who is taxable and for what in a specific country. And that is national law that decides that. And you can have different methods on figuring out then, or deciding who is taxable and for what. And there are mainly 3 different methods that you can use. And the first method is called the domiciled principle. And that means that you are taxable where you have your domicile, where you are living, where your central living interest is. We will come back to that in the tax treaties, how the definition of domiciled. But that means that you are taxable for worldwide income. It doesn't matter where the income comes from. If your country use the domiciled principle, then you will be taxable. So if I am domiciled in Sweden and I work for a few months in Germany or in Poland or in Italy or in the United States, wherever I work, I will be taxed in Sweden for that income. And that is called the domiciled principle. Another principle that a country can choose to use is called the source state principle. And that means that you look at the source of the income. So if you are working in Germany and Germany is using the source state principle, then your income will be taxed in Germany. if you have a house in Sweden, if Sweden uses source state principle, then they can tax your house because the house is situated in Sweden. But of course, if you have a house in Germany and you live in Sweden, and Sweden uses domicile principle, then the house can be taxed also in Sweden. And if Germany then uses source state principle, then the house will be taxed twice. And that is called double taxation. And that's what we're going to talk about today. How do you solve that problem? The third taxation method that a country can use is citizenship principle. And that means that you pay taxes in the country where you have your citizenship. And then you pay taxes for worldwide income. Just because you have your passport from one country, you have to pay taxes in that country for your worldwide income. And then if the country uses that, then it is the citizenship principle. A country can use more than one of those principles, and that is very common that countries are doing that. And most of the countries in the world are using the first and second principle, domiciled principle and source state principle. Very few countries in the world are using citizenship principle. But the reason why I mention it here is that we have one very big country, and that is United States, that uses the citizenship principle. So if you are citizens in United States, then you are taxable in United States for worldwide income. But beside from United States, I'm not sure if any other countries are using that principle. But since United States is so big, so it's an important principle then. Sweden are using both the two first principles, domiciled principle and source state principle. And we're going to dig deeper into that in a while and see how that works. And that is, most of the countries are using the first two. So that is three different principles that you must be able to explain what they mean. When we talk about international tax law, we have something called internal international tax law. And that means that you have national law that are regulating international situations. That means that you apply Swedish tax law on some of the international situations. And then we call it internal international tax law. And then you have something called tax treaty or tax conventions. And the difference here is that if you use Swedish tax law, then you must use the same interpretation principles as regular Swedish tax law. Because there is no difference between an international article and a Swedish article. So you use the same interpretation principles. But when it comes to tax treaties, then you have, then it is a convention, and you can't use Swedish interpretation principles on a convention because you are not allowed alone. A tax treaty is, most of the times, it is between two countries, but it can be more than two countries in some cases. We have a Nordic tax treaty, for instance, between the Nordic countries. But otherwise, it is usually between two countries, a tax treaty. And that is a regular convention, like Berne Convention or TRIPS Convention or any other convention. And then you can't use national interpretation principles. Instead, you must use the specific international interpretation principles, because you must interpret the convention the same way in both countries. Otherwise, it doesn't work. You must be a little bit more careful when you are working with a tax treaty, and you must be aware of that it can be a little bit different how you interpret the text. And the definitions, a lot of times you also have definitions in the tax treaty. We will see that as an example in the Polish treaty, where you define different expressions that are used in the treaty are also defined in the treaty. In Sweden, we have talked yesterday about, no, it wasn't yesterday, the day before yesterday, we talked about the constitutional base that we are taxed on. And I said that you can't take out taxes if you don't have a law that gives the government the right to take out taxes. So we have a principle in Sweden that says no tax without law. And then it is important then to understand that a tax treaty is really not a law. And that means that a tax treaty can never extend taxation. You can only get less tax based on rules in a tax treaty. You can't get more taxes to pay based on rules in a tax treaty. And that is a very, very important thing to remember. And for a while it was a little bit unclear in Sweden. It's quite many years ago now, but we had a judgment from the highest court, the Supreme Court, that said that the tax treaty actually could increase the tax for a person. And after that judgment came, then the parliament and the politicians started to work very hard and very fast. So they passed a new act that said that no, a tax treaty can never extend taxation. And after that act came, a new case came up to the highest court, and then the court had to change their decision because now they had a new act to apply. And then in that decision, then they said that no, the tax treaty cannot extend taxation. But the one thing that happened then after that, the second judgment, then we got a new tax act in Sweden. And then when they adopted that new tax act, they put a lot of different tax acts together into one single act. It was actually around 35 different acts that was put together in one Income Tax Act. And among those 35 that then didn't apply anymore was this new act regarding tax treaties. But they never took in the text from that act into the new Swedish income tax act. So I was a little bit confused when I realized that, okay, now they have thrown out the old act and they haven't taken in the rules into the new act. What applies now then? And when I read the preparatory works for the act, I could see that the parliament argued, or the government argued, that since we had a new judgment, a new case that said that the tax treaty can never extend taxation, then we don't need the act. So we could take away the act and then we rely on precedents, which was the last judgment from the Supreme Court. And of course, if the court should start to apply it in another way and extend the taxation again, then of course the parliament will come back and put in a new act again. Because the whole purpose is that it should not extend taxation. That is very important. That means that when you put this together, you can do a little bit of a flow chart, and that is how the way you are working when you have an international question in front of you, an international tax question. So you should always start in national law, and we always start then in Swedish national law. So we must answer the question, is this income that we have in front of us, is that income taxable in Sweden? And that is a very simple question, and simple questions have always just two possible answers. Either you say, yes, it is taxable, or you say, no, it is not taxable. You can't say, yeah, it's a little taxable. That doesn't work. It must be either a yes or a no. So the answer has just two options here. If you say no, it is not taxable in Sweden, then the answer will of course be that it is tax-free in Sweden. You don't have to pay taxes on that income. Does that mean that the income won't be taxed at all? No, it doesn't, because you must do the same thing in the other country that is involved. So then you must ask yourself, is this income taxable in, for instance, Poland? And if you come to the same answer in Poland, no, yeah, then it will be tax-free in Poland, and it is tax-free in Sweden. Then the income will be totally tax-free. But we're staying with one country first, but you must understand that you must do exactly the same test in the other country. So, taxable in Sweden, no, then it is tax-free in Sweden. If you answer yes, it is taxable according to national law, international tax law in Sweden. If you say yes there, then the next question will be, do we have any tax treaty with that country that is involved? And it's the same thing here. It's a simple question. There are just a simple answer, yes or no. There are only two options here. Either we have a tax treaty or we don't have a tax treaty. reality might not be that simple, because you can easily go wrong here. Because, and the reason for that is that a tax treaty must be approved by the parliament. Even though the tax treaty in itself is not a tax law that can, as I said, it cannot extend the taxation. But it is still a convention that must, in Sweden, be passed by and approved by the parliament, which means that the parliament will come out with a law that says that Sweden has entered into a tax treatment with this and this country. The problem with that law is that it will say in the bottom of the law text that the tax treaty will come into effect on the date when the Swedish government decide that it should come into effect. So the parliament passes a law, but it doesn't apply until Swedish government says that from now it is going to apply. And why is it like that? Well, usually you have the same situation in the other country. I mean, you have two countries' governments, the finance department from two countries. They are negotiating this tax treaty. When they have finished the negotiation and they have agreed upon the treaty, how the treaty should be worded, then of course the finance department, the government, they sign the treaty. And the newspaper starts to write that now we have signed a tax treaty with that country and so on. And the impression a lot of people have then is that now we have a tax treaty. And then they might even start to apply it. But they can't do that. Because both countries' parliaments usually must approve the treaty. Before that, it can never enter into effect. And when the Swedish parliament has this question on the table, they don't know if the other country's parliament has approved it yet. Which means that the parliament will approve it, but on the condition that the government will decide when it goes into effect. And as soon as the Swedish parliament has approved it and the law comes out, the act comes out, then the Swedish government will contact the other country's government and ask, have your parliament decided on this treaty yet? And if they say no, not yet, it will take another month, okay, then Swedish government is just waiting. And as soon as the other country comes and with information, now the parliament in our country have approved the treaty, then the two governments from the different countries will together decide on what date this treaty will come into effect. And as soon as they have decided that, then there will be a new regulation. It won't be a law, it will be a regulation, but it's published on the same place in Sweden, but it's a regulation from the government that will say that the tax treaty between Sweden and this other country will come into effect on this specific day. After or from that date, then you can apply the tax treaty. So, of course, you can go wrong here then. Because if you go in on internet into lagrummet and then you search for tax treaties and then you find the act that Sweden has a tax treaty, you can even find the treaty there. And then you start to apply it. But the government haven't yet decided when it will go into effect. Then you might think that we have a tax treaty, but we don't yet have it in place. So that's what I mean. That was a very long explanation to why it might not be as simple to say yes or no. But it must be, in a particular day, it must be a yes or no. Either we have the treaty or we don't have the treaty in effect. But it might be hard to find that out. So, if we say then that we don't have any tax treaty with the other country, so the answer to the question is no, then it means that the income will be taxable in Sweden. The income will be taxable in Sweden. If we say yes, we have a tax treaty, then we must continue and go into the treaty and see what does the treaty say about this income. And then the treaty can have two options. Either the treaty says that Sweden can not tax the income. Sweden cannot tax the income. Then it is tax-free in Sweden. It doesn't matter that Swedish national law says that it is taxable, because if the tax treaty says that it is not taxable in Sweden, then the treaty will make the income tax-free in Sweden. Because the treaty cannot extend taxation, but it can reduce taxation. The treaty can say that Sweden is allowed to tax the income. And that means that you must come this way from taxable in Sweden, yes. Because even if the treaty says that it is allowed to tax it in Sweden, if Swedish national law says no, then it is tax-free in Sweden. Then the treaty cannot make the income taxable in Sweden. So that's why it is so important that if you answer no to this first question, then it is tax-free in Sweden. Then you don't have to go into the treaty at all. The treaty can't be applied in a situation like that. It doesn't matter that we have a treaty, because the treaty can never make the income taxable in Sweden if Swedish national law says that it is tax-free in Sweden. So don't put a lot of work into studying the treaty if you have a no up here on the first question. Okay, what does this mean then in reality? Well, if you do the same thing then with the other country, let's say that we have a Polish situation in Poland then, and then you ask the same thing, is it taxable in Poland? If you answer yes to that, do we have a tax treaty? You answer yes. And what does the treaty say? Well, if the treaty says tax-free in Poland, then you have no problem. Then it is taxable only in Sweden, if you ended up taxable in Sweden. If the Polish situation says taxable in Poland, then you have both countries say taxable in their country. Then you will have what's called a double taxation. The income will be taxed twice. And since the income tax a lot of times is higher than 50%, then together it will be more than 100% tax on the income. And of course, everybody understands then that that is not acceptable. We can't tax an income with over 100%. I mean, that doesn't work, which means that we must solve that problem. And that is what the tax treaties are doing. They are solving that problem. So if you end up, according to the national law and the treaty, you end up that the income is taxable in both countries. Then you must continue to look into the treaty and see how the treaty is solving that problem. And there are different methods that you can use when you solve this problem with double taxation. And the Twitter question is one of those methods that's called the credit method. And we're going to come into that, what that means. But there are basically two methods, credit method and exempt method. And we will look into both of those two methods. Okay, so first now we are going to look a little bit more in detail then how Sweden decide the tax liability, if you are liable to pay taxes in Sweden or not. And we have different chapters in the Income Tax Act where we decide if you are taxable in Sweden or not. And the first, when we talk about natural persons, as individuals, then the rules are in Chapter 3 of the Income Tax Act. And then you have Chapter 4 and Chapter 5 that regulates not natural persons, but it can be estate, death estate, dödsbon in Swedish. And it can be partnerships that has their specific chapters that regulate tax liability in Sweden. We are only going to look at natural persons and legal entities, that is like a corporation. So if you have ett aktiebolag, a limited corporation, limited company, that is a legal entity. And then we have Chapter 6 in Income Tax Act that will regulate if they are taxable in Sweden or not. We're going to start with natural persons, tax liability. And tax liability, you can divide them into two different groups. One group is when you have unlimited tax liability. And then the other group is limited tax liability. And we're going to start with the unlimited tax liability. And we are talking about natural persons. And the law in Chapter 3, Article 3, says that natural persons living in Sweden, so if you live here, are taxable for all income in Sweden and abroad. And that is the consequence of that you are living in Sweden. The consequence is that all income is taxable in Sweden. And that is Chapter 3, Article 8 in the Income Tax Act. And that means that a person living in Sweden, I mean, that is the domiciled principle. That means that Sweden are using the domiciled principle. If you live in Sweden, then you are taxable in Sweden for worldwide income, according to this principle. And that's why it's called unlimited tax liability. Then we have something called limited tax liability. And who is going to apply those rules? Well, everyone who is not unlimited taxable will be limited taxable. So that means that all people in the whole world, everyone is has a tax liability or a limited tax liability in Sweden. Even if they don't even know where Sweden is, they have never been here, they have no connection to Sweden at all. Because everyone who is not unlimited taxable, which means that everyone that is not living in Sweden will be limited taxable. But what does that mean in reality? That means that you are taxable for specific income that are in a way connected to Sweden. So if you are not living in Sweden and you don't have an income that is connected to Sweden, then of course Sweden cannot tax you, even if they want that. They would love to tax everyone in the whole world, but they can't do that if the income is not connected in any way to Sweden. And this connection is regulated then in Chapter 3, Article 18 to 20 in the Income Tax Act. And that means in reality that we are applying the source state principle. So if the source for the income is in Sweden, then it will be taxable in Sweden. But it will be taxable with the help of another act than the Income Tax Act. We talked on the lecture about Swedish Income Tax Act and that you had a progressive state tax, and it could go up to 57% if you add the municipality tax, that was a proportional tax, 32%, and then you add the state tax, that was a progressive tax, and the highest rate was 25%. 32 plus 25 will be 57%. Those tax rules apply to persons living in Sweden. If you don't live in Sweden and you have an income, a source, an income here, and it is a regular earned income, then you will have a flat tax rate on 20%. And that is a definite tax, which means that it's taxed on the gross income. You don't have any deductions. You can't do any deductions at all. Which means that the payer, if the Swedish company is hiring someone from another country that comes in for 2 months working in Sweden, and that person is not living in Sweden just during the time he's working here, for instance 2 months, then the employer will deduct 20% of the gross income and pays that as a tax for that person. And the 80% of the income the person will get for themselves. So that is what limited tax liability means. The tax rate, 20%, comes from an act that is called SINK, S-I-N-K, and that is an act that stands for people who are not living here but temporarily work here. They will be taxed according to that act. I must look up the exactly wording here on SINK. The name of the act, I just forgot it. We always just call it SINK. I don't remember what it was in English. You see here, I'm looking in a law text book here. Come on, the law on specific income tax for people living abroad. In Swedish, lag om särskild inkomstskatt för utomlands bosatta. That is, and it's abbreviated SINK, S-I-N-K. And that law, that act says that it is a 20% flat tax rate. We're going to come back to that, what it means, a little bit later. There are a couple of exceptions from this unlimited tax liability. And one exception is what's called the 6 months rule. And the 6 months rule means that, first of all, you must be living in Sweden from a starting point. So you must be have unlimited tax liability when you start this. And if you go abroad and work for at least 6 months in another country, and that income is taxed in the other country, then you don't have to pay taxes in Sweden. That is called the 6 months rule. And you can jump between different countries. You don't have to be in the same country all the time, but you must stay outside from Sweden is more than 6 months. Then you can use this exemption. And then there is another rule that's called the 1-year rule, and that means that if you stay in one country for more than a year, then the income can be tax-free in Sweden, even if it is not taxable in that other country. But for the 1-year rule to apply, you must stay in the same country. You can't jump around in different countries. The same country. Then the income can be tax-free in Sweden, even if it is tax-free in the other country. If it is taxable in the other country, of course you have to pay tax in the other country. So the difference between 1-year rule and 6 months rule is that in 6 months rule, the income must be taxable in the other countries. If you have an income that is not taxable and you apply the 6 months rule, if it's not taxable in the other country, then it will be taxable in Sweden. And the other difference is that in 6 months rule, you can jump between other countries. But you can't come back to Sweden, except for shorter stays in Sweden. And it's regulated exactly how many days you can be in Sweden during this 6 months period. and it means that you can be in Sweden no longer than 6 days for every full month that the employment lasts, or 72 days under 1 year. That is the maximum time you can stay in Sweden if you want to apply this 6 months rule. And then there is a special rule that says if stay abroad ends earlier, let's say that you have an ambition to stay 6 months or 7 or 8 months, but then something happens, maybe a relative dies, or so you just must come back to Sweden after 4 months. Then sometimes you will be taxed then for all those 4 months because you didn't stay 6 months. So you have to pay up all the taxes for those 4 first months. But there is an exemption if the reason why you came back home is out of your control. For instance, a relative passing away, and you were not the one who killed them, of course, because then it's different. So if it's out of your control, then and you come home earlier, and it is obviously it would be very harsh for you to pay taxes for the 4 first months. I mean, let's say that you come home after 5 months and 20 days. You should just have stayed 10 more days, but you couldn't because you had to go back home. Then it would be very harsh to tax you for all those 5 months. Then you can get an exemption from that, even if you come home a little bit early. But that is only if it's out of your control. Otherwise, if you come home earlier, then you can't use the exemption and you have to pay taxes on everything. So make sure if you want to apply the 6 months rule that you really stay outside for 6 months. And don't come home too long periods. Don't come home the whole summer because that doesn't work. So shorter periods you can come home.